Good morning, everyone. A very warm welcome to each one of you to today's guest lecture scheduled by the IP cell of MNLE Mumbai. It is truly an honor to have with us Mr. Nipun Saxena, a distinguished advocate practicing before the Supreme Court of India and various high courts across the country. To brief everyone about Mr. Saxena's remarkable work would indeed take more time than we have with us today, as his journey is nothing short of inspiring. However, I will do my best to provide a brief overview of his outstanding career and expertise. Mr. Saxena's vast expertise spans multiple legal domains, including constitutional law, criminal law, technology law, white-collar crimes, commercial arbitration, amongst many others. An alumnus of the prestigious National University, Delhi, Mr. Saxena has not only contributed exclusively to legal academia through his publications, but also played a significant role in reforms in the legal industry. He has worked on landmark judgments that have shaped the country's legal landscape. Beyond litigation, Mr. Saxena frequently advises individuals, corporations, firms, and civil societies on legal strategies, compliance, and regulatory work. We are truly privileged to have with him here today, and I'm confident that his insights will greatly enrich our understanding of law and its practical application. Mr. Saxena, we eagerly look forward to learning from your invaluable experience and expertise. Thank you. I would also request the students to kindly open their barracks for CRPC and PMLA. It would greatly help you for the upcoming lecture.
Very good morning to everybody. May I request people to just occupy the front rows now? Don't worry, I promise this is going to be very interesting. You're not going to miss out much. So while you are making those logistical arrangements, might I first take this opportunity to thank Maharashtra National University, Mumbai, for having me here. And of course to Professor Velmapal. I hope you have also downloaded your CRPCs and your PMLA acts. Otherwise, most of what I'm going to be talking about might end up in a full toss. Also, have you studied CRPC? That. And its successor legislation, Bharatiya Nagarik Suraksha Sanhita. Okay, so the topic that I have been asked to speak my mind is of seminal relevance. Why is it of seminal relevance? It's because it deep dives into one specific power of police, right, which is the power to summon somebody. Now, summoning is a quintessential component of investigation. You cannot carry out an investigation unless and until you have the power to compel somebody's appearance, right? So that power to compel somebody's appearance is manifested through a summon. Now, before I take you to what the general law on the topic is and then move to specific PMLA, let's go back in history. How much back are we going to? We are going to the times of Emperor Justinian, where the first documented reference to summon was made. Unlike the summons that we have today, where a court or an authority under its seal gives you compels you to appear before itself, the summons in the erstwhile Roman Greek laws were very different. Under the Romano-Greek laws, the manner in which summons were executed was left to the person who was about to bring the claim. So for instance, let's just talk in terms of plaintiff and defendant first, okay? So a plaintiff is going to bring a cause before the court there. The onus was on the plaintiff to go and get hold of the defendant so as to take the defendant forcefully before the court. So that was the earliest form in which summons were sort of recognized. And I'm loosely using the word summon right now, okay? Let's call it compelling somebody's presence. So in order to compel somebody's presence, it was the plaintiff who would get hold of as many number of people as were present who could testify that look, X did wrong to me, and therefore it was the plaintiff, that X, as well as those number of witnesses who would all make themselves present on a certain date before a certain court or a tribunal. Understood? In fact, in jus iemus was what was called the power of summoning. When Emperor Justinian came into power, you would recollect, I don't know whether you have studied legal history in your first semester, right? I'm talking about many years back, Bar Council of India did mandate that legal history was to be taught in the first semester. So you would have heard of Emperor Justinian and his tablets, that the laws were inscribed on tablets. One of those laws, which is in specific context to summoning, was this. It said that if one summons another, he must go. If he does not go, let it be witnessed and let him be taken forcibly. So through this law, which is the first instance of a documented right or the power to summon somebody, it was that if X summons you, then you must go before the court. But in the eventuality that X does not go before the court, then you have a power to take him forcefully. And this is how summoning powers emanate from. And this is precisely that broader formula seems to have percolated to the present times. You are being asked to appear in obedience of a summon. If you do not appear in obedience of a summon, then naturally consequences will follow, right? Which is to say that the police can exercise its coercive powers to take you physically and compel you to be produced before the magistrate. Now, if you look at it from another angle, specifically in terms of Order 5 of CPC, you would see that there were three types of services that is contemplated. The first type of service is serving personally, correct? The second type was called substituted service, that let's say if you are not there, it could have been served to the next of kin, whoever is there, right? And third, if both A and B are not available, then through publication, right? CPC said dhol munadi bhi pitwaenge, all of those things, right? Beating of drums. But then publication was the last form of service. Once it was published, then it was deemed that service was duly effectuated and no further requirement was necessary. Now, the old format was that a person going to the court along with the defendant or along with the accused and along with the witnesses was what you call dasti, as we understand today. So when you argue before the courts today, you also say that in addition to the regular modes of service, we are also taking dasti. This is precisely what is called dasti, where the plaintiff or the petitioner or the complainant or whoever has brought the cause of action before the court personally undertakes to serve the defendant. Alright? And therefore, dasti service is sort of expeditious, more expeditious than the regular service of summons. Alright? So with this understanding of summons, let's come to first the law on what it is, right? And then we will go to the PMLA, and then we'll carry out an analysis of the two provisions. Acha, very interestingly, historically, there was a specific embargo or a prohibition on the power of summoning to a woman or an old or an infirm person. Okay? Under the previous law, which is the old historical law as it were, it clearly stipulated that a woman, an old aged person and an infirm person cannot be produced. Their statements are to be recorded in their house. Right? So that was in order to avoid inconvenience which is being caused to those people on account of, let's say, their age or their gender or on account of their physical inability. Physical or disability was a broader expression. So it covered physical as well as mental inability of any sort. Right? Now, in that context, let's come to the Code of Criminal Procedure. Okay? Now you would see that there is a specific chapter which is dedicated to summoning. If you look at chapter 5 of the Code of Criminal Procedure, you would see that copious references to summoning have been provided for. Chapter 6, process to compel appearance. Right? Now, if you look at section 61 all the way to section 69, you would find that there are 5 or 6 different forms or categories in which summons are to be served. Okay? The first provision, which is 61, defines what is the form of a summon. Right? 62 will tell you how summons are to be served, which I have already told you, and the manner it has to be served. Then, of course, there are different categories of person on whose service has to be effectuated. What if it's a natural person? What if it's a body corporate? What if it's a firm? What if it's an HUF? Then what you do? Right? It also contemplates a situation, section 64, that how to serve a person whose whereabouts cannot be found. Right? And then, of course, section 67 is very important, for which I would warrant your consideration. It says, when a court desires that a summon issued by it shall be served at any place outside its local jurisdiction, it shall ordinarily send such summons in duplicate to a magistrate within whose local jurisdiction the person summoned resides or is to be there served. So territorial considerations have been given primordial importance under the scheme of CRPC, that look, if a person who is, let's say, a potential witness is to be summoned, resides outside the local jurisdiction of the court, then a police officer cannot walk and ipso facto go and get hold of that person. He has to first apply to the magistrate. The magistrate of X jurisdiction will have a summon sent to the magistrate of Y jurisdiction, and it is the magistrate of Y jurisdiction who will get those summons executed. So that means what? It's not a mechanical exercise. First, the magistrate has to look at the summons. The magistrate has to apply its own mind to A, the content of the summon, B, the provisions of law which have been invoked, the capacity in which a person is being compelled to appear before the magistrate of the other court. Fourth, and to ascertain prima facie whether those summons are also genuine or not. Correct? whether the seal is properly affixed, whether the time, place of appearance has been mentioned, whether the person who is being asked to carry out the summons is in fact the person who is standing before the court, and whether there is a person whose name is summoned and that person is actually a real person or not. Right? All those things have to be considered by the court. Yes, your question. Absolutely. It can very well look, let's say if the seal was missing, then is that even a valid summon? Right? So the court can look into all of this. The entire purpose of this provision is to enable the court, because calling somebody in pursuant to a criminal investigation is a very serious action. Right? You are asking somebody to produce themselves before a court or a police station. Now that somebody may well be an accused, and therefore Article 21, 20, 22 immediately get attached. Right? And therefore to remove a person from X place to stand and answer the charges at Y place requires a meritorious examination of at least the content of the summons which are sought to be served. So, coming back to the point, section 67 harps on what? Territoriality. Correct? Now, so having understood the scheme of CRPC in chapter 6, let's also look at one other provision of CRPC, that's section 160. Now, if you come to section 160, you would see that first I talked about the form in which summoning has to take place. Now I am dwelling on who has the power to enforce the appearance or compel the appearance. That power vests in a police officer, correct? Under section 160. If you look at the heading, it is a simple giveaway. The heading of this provision says, police officer's power to require attendance of who? Witness. Now a question that of course came before the Supreme Court in a 3-judge bench, which was Nandini Satpathy versus P.L. Dami. Remember the former chief minister who was given a questionnaire. She was made to sit in the police station and she was asked to fill that questionnaire, and there were certain questions which were implicating, self-implicating, self-incriminating, and therefore she refused to answer those questions, right? And then she was accused of not cooperating with the investigation. So she filed a petition before the court under Article 226, of course, by way of an SLP, it came to the Supreme Court, and the question of law that was, of course, substantial question of law of general importance was, can a person be made to give a statement which has the effect of implicating that person and therefore would be foul of Article 20 subclause 3, right against self-incrimination. And therefore the Honorable Supreme Court said that no, the person cannot be made to forcefully give a testimony which will have the tendency to implicate herself. What the Supreme Court also said, however, which of course is not taught in law schools, is the scope and ambit of section 160 of CRPC. Because if you look at the marginal note, it says summon any witness. But in this case, she was an accused. So the question before the court was whether the expression witness could also mean an accused. Because if the Supreme Court were to hold that yes, the expression witness could also mean an accused, then automatically the filters under Article 20 subclause 3 etc. would kick in, and therefore you would see that a statement made to the police officer is inadmissible, etc., all of those things. Why? And section 25 of the Evidence Act. if you sort of look at all those provisions, a conjoint reading of all those provisions would lead to three conclusions. One, that yes, the expression witness within the meaning of section 160 includes an accused. B, that the accused of course cannot be compelled to give evidence against himself or herself because that would potentially lead to an Article 20 subclause 3 violation. But C, just because a person cannot be made or compelled to give evidence which may or may not implicate that person does not mean that the person is not bound to answer the question. It only means that the person can remain silent to those parts of the question which have the tendency to self-incriminate. But insofar as other parts are concerned, the person is bound to answer the question. So the Supreme Court in that sense sought to balance the rights under Article 20 subclause 3 as well as the sovereign power of the police to investigate. Because ultimately, forget everything. What is the purpose of any criminal trial? It is to ascertain the truth. It is not to punish somebody or it's not to exonerate somebody. It is the quest of truth, which is the dominant reason. Now, if in that quest of truth, evidence emerges which leads to somebody being implicated, then well, it will result in a conviction, otherwise it will result in an acquittal. But in that quest for truth, you need to produce people who will attest and verify whether an fact happened or did not happen, whether it took place or not take place. Right? So let's look at what are those questions that could potentially be self-incriminatory and what are those questions which may or may not be self-incriminatory. A question, let's say, to the effect that were you present at the scene of crime is of course self-incriminatory, because what does it do? It may take away somebody's defense of alibi, that I was not even present there. But the moment you ask him that question, that may or may not, that may perhaps potentially be self-incriminatory. Whereas if there is a question asked to a witness that did you know the deceased, then that may not be self-incriminatory. Right? So I'm trying to give you a bird's eye view. I'm not taking a session on what may amount to testimonial compulsion and what may not amount to testimonial compulsion. But generally speaking, Section 160 as per the law as it stands today includes both witnesses as well as accused. A very critical safeguard is embedded in the first proviso to Section 160 subclause 1. The first proviso says, provided that no male person under the age of 15 or over the age of 65 or a woman or a mentally or physically disabled person shall be required to attend at please underline this word, at any place other than the place in which such male person or woman resides. So the compulsion of appearance now takes a backseat. The proviso now says that it is only at the place where the woman or that infirm or that old person resides. It is the situs of recording of their statement shall be where that person resides. Okay? I'm so sorry if it comes across as as me feeding you Cerelac, because in order to come to the lecture, right, how PMLA affects the rights under CRPC, it is very important that you understand what CRPC says first. Any problem, abhi tak? Understood? Now, let's come to our not so favorite legislation, PMLA. Here, let's look at certain aspects. The first thing that I want to consider is chapter 5. If you read chapter 5, which starts from section 16, all the way to section 21. For our purpose, 16 to 21. Because 20 to 23, 24 deal with burden of proof, yada yada. That we are not concerned with. Okay? Can you look at the head note of chapter 5? What does it say? The very first word says summons. But please look into the chapter. Please find if there is any mention of summon after this place. No. You see what is the foul play which is happening. You mention in the heading summons, but then summons is conspicuously absent throughout the provisions itself. So if you look at section 16, which is power of survey, section 17, search and seizure, section 18, power of search of persons, 19, which is arrest, 20, which is retention, and 21, which is 21, which is retention of records, and 20, which is retention of property, you will come to the conclusion that the expression summons is missing. So the first question that we have to ask ourselves is what? Do you even have the power to summon? There are at least 4 things missing. A, power to summon. B, summon itself, what is to be the form, how it is to be served, in what form it has to go, right? And third, what happens to those X number of contingencies which have been envisioned under chapter 6 of CRPC, which are now conspicuously absent. The simplest answer to this would be that, of course, it does not mean that you don't have the power to summon, because that power to summon is specifically recognized under section 50, which is in a different chapter. But please understand again, you would appreciate that the chapter 5 itself says what? Summons, seizures, etc. And summons is missing. Is this a legislative misfire? Is it a case of omission? And let's go to chapter 8, which actually defines what are authorities. And there, while they have described what those authorities are, we come to that one sinister inclusion, which is section 50. Okay. And we'll read it together. Powers of authorities regarding summons, production of documents, and to give evidence, etc. The place which ought to have mentioned what a summon is absent, but the power is recognized. The power to summon is recognized without the content or the form of summon itself, and how it is to be served, on who it is to be served, who are excluded. All those 5 questions remain unanswered. All that is mentioned is that yes, you have a power to summon. Now, the director shall, for the purposes of section 13, have the same powers as are vested in a civil court under the CPC while trying a suit in respect of the following matters, namely what? Discovery and inspection, enforcing the attendance of any person, including any officer of a reporting entity and examining him on oath, compelling the production of records, receiving evidence on affidavits, issuing commissions, D, any other matter which may be prescribed. Now, subclause 2 is important. The director, additional director, joint director, deputy director or assistant director, 5 people, shall have power to summon any person whose attendance he considers necessary, whether to give evidence or to produce any records during the course of any investigation or proceeding under this Act. Okay? Please look at the expression to give evidence, to produce any records during the course of any investigation or proceeding under this Act. Subclause 3 then kicks in. So, all the persons so summoned shall be bound to attend in person or through authorized agents as such officer may direct. He may or may not, but if he directs, you are bound to be present. and shall, now this is the funniest part, and shall be bound to state the truth upon any subject respecting which they are examined or make statements, and produce such documents as may be required. Now please look at it and compare it with section 160. Was this ever there? That you are bound to state the truth. If you don't state the truth, then what is the consequence? Let's look at the consequence. The consequence emanates from section 63. 63 says punishment for false information or failure to give information. So he is bound to say the truth. He may say a lie, or he may not say anything at all. Now if he may not say anything at all, then the guarantees and the protections which are contained in Nandini Satpati will come to his rescue, because it says, oh look, if it is incriminating and if you are an accused, then you are not bound to answer the questions truthfully. You can maintain silence, and your silence shall not be construed as non-cooperation. Otherwise it would have a tendency to implicate you. But now if you look at this particular provision, the manner in which it has been drafted, section 50 subclause 2, it says, sorry, you have to answer truthfully. Because, and on your failure to answer truthfully, the consequences under section 63 follows. What does 63 say? 63 subclause 2 says, if any person being legally bound to state the truth of any matter relating to an offence under section 3 refuses to answer any question put to him by an authority in the exercise of its power, or refuses to sign any statement, or to whom a summon is issued under section 50 either to attend or to give evidence or to produce documents or books of accounts at a certain place and time, omits to attend or produce books of accounts, he shall pay by way of penalty a sum which shall not less than 500 or which may extend to 10,000 for each such default or failure. That's not that problematic. You have of course prescribed for a penalty, that's fine. Now where does this assume proportions? It assumes considerable proportions under subclause 4, because now it says notwithstanding anything contained in clause C of subsection 2, which is that summon wala clause. 2C was summon, and now a non-obstante clause kicks in which says notwithstanding anything contained in 2C, a person who intentionally disobeys any direction issued under section 50 shall also be liable to be prosecuted against section 174 of IPC. Section 174 of IPC prescribes 6 months of imprisonment. So now if you fail to go, or if you even go and fail to disclose, or even if you disclose, you do not disclose the relevant portions because you feel that it has a tendency to self-implicate, the police, the ED now has the power to carry out its coercive, exercise its coercive powers against you and implicate you for violation under section 63 subclause 2 read with section 174 of IPC. The question that I ask myself is, what about the protection under Nandini Satpati? Is it good enough to say and argue? Because of course as constitutional law, in criminal law, we read this self-incrimination day in and day out. And thanks to this one inclusion, the problem has compounded tremendously. Let me read something else for you. And I'm just leaving you with these thoughts so that you can apply your own mind to it. While we are nearby, let's also look at section 65 of the PMLA. 65 says, Code of Criminal Procedure to apply. The provisions of the CRPC shall apply, very important, insofar as they are not inconsistent with the provision of the Act. Again, to arrest, search, seizure, attachment, confiscation, investigation, prosecution, and all other proceedings under this Act, which include summoning. So, a good way to strike a balance would be that if a person who is being summoned happens to be an accused, then the protection under section 160 will kick in. If that person happens to be a woman, that woman may not be asked to appear before, let's say, the ED's police station, let's call it that, or the ED headquarters, fancy way of putting it. Right? And the person may not be compelled to give any testimonial compulsion which has the tendency to self-incriminate. That's a harmonious reading of the two provisions.
But I think the section 50 clearly states that all persons are bound to attend in person.
Yes.
So wouldn't the term all persons be inconsistent with the proviso to 160 and hence will be considered superior to that?
How?
Because all persons would also include women, elderly people and infirms, right? And since we are to give prominence to the PMLA Act first, because any inconsistency, the PMLA Act overrules the CRPC. So wouldn't the all persons phrase be more important than the proviso to 160?
Before going to the proviso, what does the first provision itself say under 160?
Witnesses. That any police officer making an investigation may require attendance
Again, required attendance.
of
Right.
any person.
So it does require attendance. But here, so the main provision are almost similar.
Right.
It's only where the proviso carves out an exception, because the proviso also recognizes that all persons are here just as they are there. So it's not a case of inconsistency, but it's an exception which is carved out in the proviso. Correct? Right?
But sir, proviso is also part of section 160.
Sorry?
So proviso is also part of section
That's
160. So we have to read that section in whole, not as a separate.
Absolutely, which is why now I read it as a whole. That while it asks everybody to be there, for three categories of individuals, that are women, infirm and aged, it carves out a distinction. And that distinction, it is not to say the provision of PMLA Act section 50 is not worded in a manner which says that the proviso contained in section 160 is not applicable. It does not exclude, because it could have, if they wanted to exclude women or a child under 15 years of age to come and depose to a police station, then they could have well excluded it, but they did not.
So they added later, right, that any inconsistency this will remain.
Of course, but then it's only to the extent of inconsistency. There's no inconsistency in that sense.
So the only difference that I notice is in the word of all. So section 50 subsection 3 of PMLA says that all persons who summon.
That's correct.
Whereas section 160 of CRPC talks about any person.
Yes, so any person can be any person,
Right.
but that any person no longer remains any person, it is that person who has been summoned. Police officer may summon all of you. But if this police officer decides to summon only this portion and not this portion, then all who are summoned are only all of these people, not these people. है ना? ठीक. Can somebody increase the AC? I'm sweating profusely. या इस साइड कर दीजिए. Now, the first problem, in my estimate, of section 50, but just to complete the narrative, let's also go to section 71. Act to have an overriding effect. Right? Notwithstanding anything inconsistent herewith contained in any other law for the time being in force. So to the extent of consistency, harmonious interpretation. To the extent of inconsistency, the Act overrides. Right? Yes, but in the absence it would be CRPC, because unless something specifically is inconsistent in the PMLA Act, the CRPC prevails. So for something to be inconsistent, the inconsistency has to be codified in PMLA. It's not that omission to include anything will result into inconsistency. Because if you start reading provisions like these, then all your constitutional safeguards will go into a dustbin. Right? So it is only for inconsistency to be there, the special law, let's formulate those principles of law. The special law, A, it has to be a special law. B, generally a specially must non-derogate, the special law must prevail over the general law. C, the special law must now be codified, specifically codified, to bring out that inconsistent provision, which will only and only then kick in by virtue of section 71. So there has to be something which is codified, that something has to be inconsistent with the general law, and only then when A and B are met, then the fiction which is under section 71 will trigger. Okay?
If anything is given to any right under general law.
Sorry?
If anything is given to any right particular.
Yes.
Nandini Sarpati says that it gives you a right. And that does not say that it should be read only in the context of CRPC, because it is also being linked with the fundamental right. Then we read this section 71. These summons down under the
50.
So don't you think so that is not verified the effect of Nandini Sarpati?
I hope to God if Supreme Court did share your views like that. But then came Vijay Madan Lal Chaudhary. And we'll come to that by and by. Right now, what we are doing is, I think I am teaching you addition and subtraction. And then we'll go to algebra. So the provisions you guys have been able to understand. Now what happens is, the first question is, who am I under section 50? If a summon is being issued to me, in what capacity am I being called? Am I a witness? Am I an accused? Because in Vijay Madan Lal Chaudhary, the first question before the Supreme Court was whether the provisions of CRPC would apply. Of course, it was in the context of bails, it was in the context of summons, it was in the context of arrest, it was in the context of so many other things. So the Supreme, and therefore the vires of different provisions of various sections of PMLA were called into question before the Supreme Court, and therefore a 3-judge bench of the Supreme Court passed a judgment, which unfortunately is the law which still stands, which took care of some of those things. The first question was, how am I being summoned? In what capacity am I being summoned? Am I being summoned as a witness? Am I being summoned as an accused? Because if I am being summoned as an accused, then Article 20 sub clause 3 kicks in. If an FIR is registered against me, I have a right to have a copy of that FIR, right? In terms of Youth Association judgment, which says that even before the stage of compliance of 207, because 207 will come in much later. 207 will kick in only when charge sheet is filed, it is produced before the magistrate takes cognizance under section 190, and then the magistrate summons you, and then in obedience of that summon you are produced before the magistrate on the first date of hearing. Then and only then, the complete copy of the charge sheet is handed over to you. The Supreme Court said, nonsense. An accused cannot be made to wait for all this time to be given a copy of the primary document which implicates him. And therefore, in terms of the Youth Association judgment, the Supreme Court said, categorically might I add, that a copy of the FIR has to be furnished to the accused free of cost forthwith. Okay? How? Why? So that the accused knows what is the allegation. Even if, of course, an FIR is not an encyclopedia and all those line of judgments, but the primary allegations are something that the accused would be aware of, so that the accused can then mount his defense. Right? So if the accused finds that, sorry, I was not even there, or that this person, somebody is accusing me of murdering, let's say, Nelson Mandela, I was not even born then. So the accused not file a quashing petition immediately and get the entire proceeding set aside? Of course. So FIR therefore is a very vital document which had to be given to the person. But under the Vijay Madan Lal judgment, the Supreme Court said that ECIR, which is the equivalent of an FIR, is an internal document of the ED, and the accused has no right to be given a copy of it. So the accused has no right to be given a copy of the ECIR. So today, now imagine a situation. Under trials in PMLA, a person, I'm just calling him a person receives a summon under section 50. The summon is silent. It doesn't say whether you're being called as a witness. It just says you appear to be acquainted with all the facts. And now the person is standing before the officer. And now he's bound to say everything truthfully, might I add. Because if he doesn't say anything truthfully, then he goes. It's like you have blindfolded a person and sent him into a dark room, not knowing what is there. And that's precisely how sinister this law is. It does not even tell you in the capacity in which the person is being summoned, whether he is an accused, because if he is an accused, then those protections will kick in. But if he is unaware and goes there and makes a statement, then those self-implicatory statements may come to haunt him. Because in Nandani Satpathy itself, the Supreme Court had clarified that if you are being summoned as a witness, then you are bound to answer. And it is only later that you are implicated as an accused, then those statements that you made can be used against you, because at the time when you gave that statement, you were a witness, not an accused. Yes. Vijay Madan Lal stands. ECIR is an internal document. Nothing. That's why. Why do you think most of my clients are in jail? Sometimes I forget I'm being recorded. So, it's okay. So now that you understood the entire scheme, let's quickly come to the attack. First line of attack. Who the hell drafted this provision? What sort of drafting is this? Legislative? A, it does not specify the form of summons, how it is to be served, and what are the exclusionary categories. Right? Second, we spoke about territoriality. Territorial considerations are given primacy, since we had already read those. Right? Whether it is in chapter 6 or whether it is in section 160. Section 67 as well as section 160 give primacy to territoriality. Now, an ED office headquarters situated in Delhi is summoning a person in Kerala. Or let's take Nalini Chidambaram's example. Chennai. Come from Chennai here in Delhi to give your statement. K. Kavita. All these cases, Rana Ayub, ED headquarters in Delhi or Mumbai will summon people from Kashmir, Kanyakumari, Kerala, Tamil Nadu, Chhattisgarh, Madhya Pradesh, Himachal to come and depose. Is that not problematic? Right? Does that not impinge upon the fundamental guarantees that are envisioned under section 160 and 67 of CRPC? And mind you, there is no inconsistency as such. In fact, let me take another proposition. 50 subclause 2 says you are bound to answer truthfully. There was almost, I mean, I would not say similar, I would say a slightly lesser provision with lesser implications, if I may. Under section 67 of the NDPS Act. In section 67 of the NDPS Act, the same question came before the Supreme Court saying, what happens to a person who is asked to give a statement regarding possession of narcotics on his person? Because the statement being given under the NDPS Act, they said, is not equivalent to a statement under section 161 of CRPC, which says they are not admissible. Therefore, the NDPS officers made, NCB of course, made a plea before the Supreme Court saying that these statements are admissible, just like Income Tax Act. And therefore, if an SSE makes a statement there, and let's say an accused makes a statement here, that should be, even if it is self-incriminatory, it is admissible. Supreme Court said, no, how can you do this? Article 20, clause 3 applies with equal force. It does not matter whether he is being charged under a general offence, IPC offence, or under a specific NDPS Act. You cannot extract, otherwise this will lead to torture. This is institutionalization of torture. The police wala will whack one or two and you will ask, write here, sign here. He will sign and there is no point of a trial there. So that section 67 of NDPS Act in Tufan Singh's case, Supreme Court was very categorical. Said you cannot compel anybody to give a statement. You cannot compel them to answer truthfully, which is why you would see that signatures are not required for a statement to be given before the police officer. Otherwise, you would say that, oh, all right, the content of what you are saying may be inadmissible, but he will bring a handwriting expert to prove your signature and say, then by inference, whatever you said, if you say it was your signature. People are smart, no? Which is why Macaulay was smarter. And this provision also existed in the 1898 CRPC. Because Macaulay said, please do not trust the police. And very rightly so. People blame him for whatever it's worth. But from the year 1830 till the year 1860, he spent 30 years before he drafted IPC. He was not a fool. He spent 30 years in India to come out with that version. Now, that's one. Let's look at number two. CRPC, now the Supreme Court in a recent judgment by Justice Veera Trivedi passed a series of scathing orders against all these people, Nalini Chidambaram, K. Kavita, as well as Abhishek Banerjee, Rujira Banerjee's case, and said that in terms of Vijay Madan Lal Chaudhary, ED officers are not police. ED officers are public servants, but they are not police. And since they are not police, therefore any protection against police is not applicable to them. But please make me understand, and I am talking as a layman. If you are conferring power of arrest, search, seizure, then what are you? If not police. And let's forget, are you not exercising police-like functions? And if you are exercising police-like functions, then will nomenclature make any difference? Oh, these are officers. Look at them, they are deputy director, assistant director, falana, dhikana, but ultimately they are exercising the same powers as if a police officer. And that's the second problem.
Sir, if police is not, if ED is not police, then the statement given to him are admissible, right?
Imagine the Pandora's box that will open. It may be, but then you can use the same thing for NDPS. You can use the same thing for NIA, National Investigation Agency Act. You can use the same thing for customs. Can you be louder? Use this here. while you are, I will just finish because I think there is a time this thing also, and I will respond to your question later. Okay. Now, the third problem was in Justice Bela Trivedi's judgment. Right, was that please look at section 50. It is gender neutral. Section 160 is not, and therefore a woman can be summoned at the PMLA. Please go to General Clauses Act. Expression man also includes woman. A person also includes a female. What rationality is that? Right? Do you think the Parliament, of course, which is why General Clauses Act was enacted, that a person may also, singular may also mean plural, man may also mean a woman, or a third gender in terms of Nalsa judgment of 2014. So just to say that section 50 is gender neutral and therefore you can call anybody, if that, even let's assume, let's humor ourselves with that logic. Let's play with that logic. Can a woman not be disabled? So now it is no longer gender neutral? Because section 160 applies to disability also? Can you now ask a specially abled person to come and depose and travel all the way? And whatever happened to CRPC's territoriality? You have your zonal offices, EDS 5 zonal offices as per the Finance Act. Now if EDS 5 zonal offices, it may augur to reason that let's say somebody in Gujarat is being summoned by AD Bombay. That's fine, because Western zone. Understandable. But can Mumbai now call somebody from Kashmir? The entire purpose of territoriality, and let's also go to those provisions of CRPC 176, 177, 178. Every crime shall be investigated into, tried or inquired by the police within whose local jurisdiction the offence has been committed. When people enact laws without elementary understanding of drafting, this is what happens. Let me give you another example. And I'll leave you with that thought. Zero FIR, wonderful, wonderful. Everybody is praising zero FIR like anything. Right? If you brought a zero FIR, then you ought to have amended the BNSS accordingly. Because a person, while you may say that in a rape case, a person sitting in Gujarat, whoever is sitting in Gujarat, can file an FIR at Gujarat. Very good, laudable. But that still doesn't answer the question, which police will investigate, Maharashtra or Gujarat? Local limits within whose jurisdiction the offence was committed. Somebody goes to Goa for a party, gets back, let's say an offence takes place there, and then goes back to Gujarat and files an FIR. Now, and the accused lives in Maharashtra. So which police? Maharashtra, Goa or Gujarat? Zero, no answer, nothing. Section 21NA of PMLA defines investigation. So my question to myself was that you say police is known because they investigate. Police is police because its function is to investigate. Now if the same investigation is defined under the Act, then if the ED officers are carrying out this very same investigation, what are they? No, but they cannot be called police. Sorry. Which is why the Vijay Madan Lal judgment now requires a serious reconsideration. And because I think that the time is ending, right? I will leave you with one speech that Macaulay gave in one of his papers on 10th of July 1835 before the House of Lords there. When he tries, and by the way, contrary to popular perception, England, I mean those of them who say that these laws were British heritage and coloniality and they were dropped on our heads. Absolutely devoid of logic. Because Britain at that time did not even have a codified criminal law. So the first instance of a codified criminal law was in India. And in his speech, I quote, and I will end my session on that note. He said, 10th July 1835, uniformity is the chief end, and special definitions, procedures, or other exceptions to account for different races or sects should not be included without clear and strong reasons. Macaulay had these principles in mind as early as his parliamentary speech on the Charter Act, where he declared, uniformity where you can have it, diversity where you must have it, but in all cases, certainty. The Act of 2002 is anything but certain. It's anything but diverse. And it is anything which is uniform. And which is why it's a standing affront to Article 21. The Act as it stands. Thank you so much for a very nobody slept, and I'd be happy to take any questions now if you have.
Sir, all these
Why have you come?
Sir, all these conclusions that you told us, that 250 and then 116 PMLA and then CRPC, BMSC or whatever, but how are we tackling those? Are we leaving it on judicial interpretation, or how in practical sense are we tackling those?
We thought we would leave it to judicial interpretation, which is why those appeals came all the way to Supreme Court.
Problems that were mentioned.
Your mic is working.
Not but it is investigating whether the crime has been laundered by the person or not. Because of police strategy, the predicate agency is already investigating the predicate offense. So, sir, shouldn't we distinguish the and the police?
Because if you look at section 44 and 46 of the PMLA Act, it clearly says that wherever there is a predicate offence which is being investigated along with a money laundering offence, the predicate offence shall subsume and the special court will hear both cases together.
That if we equate with the police, what would be difference in the functioning detail?
Well, if you equate police and if you say that ED for all intents and purposes is police, then all the protections that are available to you against police will apply with equal force against ED. But since you cannot do away with those safeguards which are mentioned in every word, every provision of CRPC, therefore you attack the definition of police itself and say, sorry, police is established under the Police Act of 1861 and ED are special force. But if that is the case, then what about customs, what about FERA, FEMA regulations, what about NIA, what about UAPA under, what about STF, what about CID? It's, how do I say, I don't want to use the expression, but I have an expression in mind. Sorry. That's very good, no? That's a very nice job. But what is the bench strength in Senthil Balaji? What is Vijamadan Lal? You are right, you are absolutely right. This is precisely which is why I am pitching it to the point of Article 20, 21, 22. I am saying that the rights which are recognized under CRPC have constitutional foundations. Even the Romans and the Greeks never did what they are doing. If you claim yourself to be a progressive society, then 2000 years people who lived before you were smarter than you. At its very best, it's a draftsman's nightmare. And at the very highest, at the very worst, it's sinister. It's draconian. Because what is the effect? You summon somebody, he doesn't come, you throw him in jail. The person does not even know what he is. Article 21 is being flouted left, right and center. You don't know how he is to be served. Again, thank you for that question. Very recently, because what ED officers have started doing was, they started sending you summons on WhatsApp. Correct? In Satyendra Antil, very recently, the third Satyendra Antil, the Supreme Court had to clarify, please stop this nonsense. When CRPC specifically says has to be delivered in person and PMLA Act is silent, then will CRPC not apply? But please understand, for some things you are saying CRPC will apply, for other things you will say the CRPC does not apply. Will it not give rise to confusion? And forget about confusion. Confusion in a general civil law is alright, you will litigate it out. Confusion in criminal law. Somebody's right to life and personal liberty is at stake, you can throw somebody in prison.
Pankaj Bansal said that we have to provide the grounds of arrest.
You like your mic, what?
Sir, Pankaj Bansal, I think he said that we have to provide the grounds of arrest.
Yes.
So wasn't that?
That's right. You have to provide the grounds of arrest because again, Justice Oak's judgment are wonderful because he understands the limitation of VMC and therefore he says forget VMC, we are linking it to Constitution itself.
That will be a virtual overview.
Haji?
That will be a virtual overview of the
If only. He never entered into that controversy. Because otherwise if you look at Nikesh Tarachan Shah, when those twin conditions of bail under section 45 of the PMLA Act were negated by Justice Nariman, any student of criminal law, please read that judgment. Please, I implore you, Nikesh Tarachan Shah, one of the finest specimens of judgments ever authored in recent times. And that was overruled by Vijay Madalla. Because what happened was, section 45 was struck down by the Supreme Court, the Parliament brought in another amendment, not only bringing back those twin conditions, and I can have another lecture only on 45. It's that bad. Yes, any other questions? Cheek. Thank you.
As we conclude this insightful journey, I would like to express our heartfelt gratitude to Mr. Saxena for sharing his invaluable insights with us today. Your thoughts have not only enlightened us, but also sparked new ideas and perspectives that we will surely carry forward in our academic journeys. Before we end this lecture, I would like to acknowledge the unwavering support that makes such sessions possible. I sincerely thank our Honorable Vice Chancellor Sir, Dr. Dilip Oke, our Registrar Sir, Dr. Pratap Sarangi, our faculty in charge, Dr. Garima Pal, and our placement officer, Dr. Vaibhav Sonale, for their tireless efforts in arranging such sessions for us. Thank you once again, Mr. Saxena, and to our audience as well. Thank you.
Thank you guys. Thank you so much.
19, 20, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34,